Where an individual, company, organization, or even a country is considered to have acted illegally, it is possible for the rest of the global community to take action against that abuse. One mechanism by which such action might be taken is the use of financial sanctions. Financial sanctions prevent the use and movement of monies relating to certain individuals or organizations considered by the international community to be unfit, usually due to relationships with crime or terrorism. In this way, those committing illegal actions should not be able to benefit financially from those actions, which should reduce the motivation to commit those abuses. Organizations such as the UN maintain a sanctions list, and financial services firms should seek to minimize the risk that they are servicing customers who are subject to financial sanctions. In some countries, such as the UK, legal sanctions are imposed on firms or individuals found to have breached financial sanctions. Aside from any legal penalties, failure to recognize such cases exposes the firm to reputational risk. Negative publicity about a firm which indirectly supports terrorism will likely prevent people from doing business with them. The international frameworks for financial sanctions do not prescribe the processes which firms have to adopt to achieve compliance with their legal obligations. The guidance below is intended to provide an indication of the types of controls and processes that firms might adopt in order to enable them to comply with sanctions obligations in an effective and proportionate manner. Firms should have processes to manage the risk of conducting business with or on behalf of individuals and entities on the list provided by their government or directly from the UN and other appropriate sanctions lists. Some countries provide a consolidated list, which includes all the names of sanctioned persons and entities under UN and EU sanctions regimes, which have effect in the country concerned. Firms should consider screening their customers and transactions on a periodic and/or ongoing basis. The scope and complexity of the screening process will be influenced by the firm's business activities and depend on the profile of the firm. An effective screening process should include the following elements. It should flag up potential name matches against the consolidated list and names against which measures have been issued, for example, in the UK under the Counter-Terrorism Act. Potential matches should be reviewed by appropriately trained staff. Many firms use automated customer screening software provided by a commercial provider, whereas other firms rely on manual screening. Firms may consider whether and what type of screening software to use in line with the nature, size, and risk profile of their business. A key element of a screening system is that it will flag potential matches and clearly and prominently. Firms should document the reasons for choosing whichever screening method they decide to use. Where commercially available automated screening software is implemented, firms should understand the software's capabilities and limits and make sure it is tailored to their business requirements, data requirements, and risk profile. Firms should also monitor the ongoing effectiveness of automated systems. Where an automated screening software is used, firms should ensure that they have adequate contingency arrangements in case the software fails. Also, firms should periodically check that the software is working according to standards. It is important to consider fuzzy matching, which is a term used to describe partial or potential matches. Some software solutions identify possible matches where data in official lists or in firms' internal records is misspelled, incomplete, or missing. They are often tolerant of multinational and linguistic differences in spelling, formats for dates of birth, and similar data. A sophisticated system will have a variety of settings, enabling greater or less fuzziness in the matching process, as appropriate in line with the risk profile of the business. The generation and resolution of an undue number of false positives may have a negative impact on the efficacy of the resolution process. Therefore, firms should consider the level of appropriate human intervention to assess which results may be false positives. All customers should be screened during the establishment of a business relationship or as soon as possible after the business relationship has commenced. Firms should be aware of the risks associated with screening customers after a business relationship has been established and/or services have been provided in case they may transact with a sanctioned party in breach of sanctions prohibitions. Firms must be aware of the absolute restrictions embedded in the financial sanctions regime. Where there is any delay in screening, firms risk breaching the legislation. A firm must apply enhanced due diligence measures on a risk-sensitive basis in any situation, which by its nature can present a higher risk of money laundering or terrorist financing. As part of this, a firm may conclude, under its risk-based approach, that the standard evidence of identity is insufficient in relation to the money laundering or terrorist financing risk, and that it must obtain additional information about a particular customer. Therefore, as part of a risk-based approach, firms may need to hold sufficient information about the circumstances and business of their customers for two principal reasons. Firstly, to inform their risk assessment process and thus manage their money laundering terrorist financing risks effectively. And secondly, to provide a basis for monitoring customer activity and transactions, thus increasing the likelihood that they will detect the use of their products and services for money laundering and terrorist financing.